think I'm going to get started because I want to make sure that we have enough time for questions and everything in the discussion at the end. If anyone has anything to add or any questions to ask, I'm happy to have that. So I'd like to kind of introduce myself, and today our training is going to be about the fundamentals of supplemental security income and social security disability income. And basically just a little bit about LegalHealth. Many of you, of course, are familiar with us, but just a little refresher. LegalHealth is a division of NYLAG, and we provide free legal assistance and develop policy to help New Yorkers who are experiencing financial hardship and have serious chronic health problems. We are a medical legal partnership, and we are a part of NYLAG, which is a leading nonprofit that provides free legal services in New York City. So a quick overview of Social Security. Social Security Administration administers different types of benefits: Social Security disability benefits, SSI, survivors benefits, and retirement benefits. All of them are slightly different, and today we're going to talk about the first two, the SSD and SSI portion of it. So these two programs are different in a very fundamental way. One is the Social Security Disability Program is a benefit from a patient's own Social Security account when that person becomes disabled and has work history. Supplemental security benefits are for low-income elderly or disabled people with insufficient or no work history. A little chart to sort of make it a little clearer. There is a income and resource test for SSI, and there isn't one for SSD. Work history is not required for SSI, and it is for SSD. But immigration status and medical evidence of disability are basically the same for both benefits. So that is kind of where we're going to lean into and focus on today. So speaking about immigrants, what are some eligibility restrictions? Depending on an immigrant status, entry date into the US, and years here, that person may be eligible for Social Security benefits. For Social Security disability, they must have a green card and sufficient on the books work history. And we'll kind of go through a little bit later what that means. And for SSI, they must be in a qualified alien category, and there are 7 of them, and we'll go through those as well. And they must be lawfully residing in the US on or before this very specific date, August 22nd, 1996, and collecting SSI and blind or disabled, or they must be a legal permanent resident with 40 qualifying quarters of work. So these are the 7 categories of a qualified alien, and this slide is a bit dense, but I wanted to make sure that we can see exactly what is listed under those categories. And basically, these are people who are conditional entrants, are paroled into the United States, are refugees, or were granted asylum. Now, I want to highlight this a little bit because often we get questions about people who have applied for asylum. And if any of you practice immigration, you may know that asylum can take a very long time to process. And a lot of times a person can have a work permit or another type of benefit that makes them think that they have some sort of status in the United States while their asylum is pending. So a person who has a pending asylum application will not be eligible. It is a person who needs to have a granted asylum application. A person whose deportation is being withheld, usually this is for reasons like unable to return to the country because of war or a natural disaster situation, or a Cuban and Haitian entrant. And the definitions for all of these are in these very specific sections of law. So if there's a question or you have a client with that, it's very important to sort of look it up and make sure that they fall in under one of those categories. Again, the income and resource issues are coming up specifically for SSI mostly. There is a resource limit for SSI. It's $2,000 per individual person and $3,000 per couple. And the applicant's monthly income cannot exceed SGA. Now, SGA is substantial gainful activity, and that is basically what a Social Security deems as a person making enough money to not need a benefit. or that they're working enough that they're not disabled. And we'll see a little bit more about how they figure that out in a minute. But for 2022, the current SGA limit is $1,350 a month for non-blind individuals and $2,260 a month for blind individuals. So basically, this comes into play if a person already has disability and begins working, or if a person is applying for disability and is continuing to work and making more money than this, it is considered substantial gainful activity, and it is unlikely that they would be approved for the benefit. So the work credits question is one that comes up often personally with my clients and our partners like social workers and other people, because when they're trying to figure out if somebody is eligible, it is a little bit complicated. So apologies for the density of this slide as well, but I wanted to kind of make sure that we have all the information that we need. So basically, to qualify for Social Security disability, as we talked about, you do need to have substantial work history, and that work history has to be recent enough. So through your taxable employment income, you accrue these work credits with Social Security, and they're based on your total yearly wages or your self-employment income. Now here, I get a lot of questions for some of my clients are self-employed or are contractors, and basically what ends up happening is they may not report all their taxes, or they're reporting only portions of their taxes, but you can earn up to a maximum of 4 credits per year, and the amount needed for credit changes every year. It is increased every year just a little bit. So in 2022, you can earn 1 credit for each $1,510 of wages or self-employment income you make. And when you've earned $6,040, you've earned your maximum of 4 credits per year. So as you can see, it's not a huge amount of income that is necessary, but it is necessary for it to be consistent, because it also depends on your age when you apply for Social Security disability. And generally, you would need about 40 of those credits, 20 of which have to be earned within the last 10 years. Younger workers may qualify with fewer credits, and there's a chart on the SSA.gov website that you can access, which basically says if you become disabled between 20 and 25 or 30 and above and so forth. So it will tell you exactly how many credits you need, but generally it's about 40. Younger people, it may be less. So in other words, you would need about 10 total years of full-time work, which would equal 40 credits, and 5 of which occurred in the last 10 years. The date of eligibility, when that eligibility ends, is called the date last insured, or DLI. And your disability onset must happen before this date last insured. If not, you will be denied because you're no longer covered by this Social Security disability sort of policy, how they call it. So it's extremely important also that even if someone had a lot of work history, that they worked recently enough, because their date last insured could be far back and they may not be covered by SSD anymore. So Medicare and Medicaid, that's tied to Social Security. It is. Medicare benefits will start 29 months after the onset date of disability. Now, the reason why it's not exactly 2 years is because there is a 5-month waiting period after the date of disability before a person is able to receive their benefits. And that gets added to the 24 months, which would equal 2 years. So that's how a lot of people who are younger have Medicare. I think I get that question all the time, is how is someone eligible for Medicare before age 65? And this is how. And all SSI recipients automatically receive Medicaid benefits because it is a means tested benefit. And so usually a person is eligible for Medicaid if they're eligible for SSI. And those benefits can start 3 months before the date of onset. So they can cover bills further back. Medicaid will back pay some of those bills. And SSD beneficiaries are eligible for Medicaid as well if their monthly income is below the $934 Medicaid limit. So basically, this is a chart just to make it a little bit easier to see. Again, Social Security disability has no income or resource test, doesn't really have a resource limit. SSI does have an income and resource test, and there's other basically issues about work history. One thing to note here too is that there are some auxiliary benefits. There are survivor's benefits that people can get if they've earned SSD. There are no auxiliary benefits from SSI. And also physical presence in the US is not always required. A person can get SSD because they sort of earned it and they could live elsewhere and continue to receive it. However, if you are out of the country for a long period of time, for more than a month or two, your SSI benefits may get cut off. So that's something to keep in mind as well. Now, how do we define disability? How is it defined in Social Security, in the Social Security standard? And they have a very specific definition that applies to both programs. It's exactly the same. And it's this, it is the inability to perform substantial gainful activity, which we talked about, by reason of a medically determinable physical or mental impairment or combination of impairments, which has lasted or is expected to last at least 12 consecutive months or end in death, taking into account the individual's age, education, and work history. So that's kind of a mouthful, and let's break it down a little bit. There are really four major factors. Applicant has to be unable to be gainfully employed. Applicant cannot perform the same work as they did before the disability started, and they cannot perform any other types of work because Social Security does look back about 15 years into your work history to see if there's some other job you can do if you can't do the job that you were doing right before you got sick. And is the disability expected to last at least 1 year or result in death? Now, I kind of want to highlight this last part because a lot of the time when we work with cancer patients, they may have an extremely serious diagnosis, which fortunately can be treated rather quickly, and sometimes they can get better in 6 months or 8 months, and so the timing here becomes an issue when trying to prove disability and the eligibility for disability. So sort of a practice tip is often we link the physical effects of the actual treatment, sometimes with any kind of side effects that follow that treatment, or any kind of mental side effects that may happen, because as you probably know, a lot of people with cancer can have depression or other mental health issues. And so sometimes that can be quite lasting and last way longer than a 6 or 8 months treatment. So that is sort of how we can a lot of the times prove that someone continues to be eligible for disability. So this is the 5-step determination process for Social Security. Again, those are sort of the questions that we ask, and if you answer yes, then you're automatically denied, and that's sort of the process that that Social Security goes through in order to make sure that a person is eligible. Now, the first two are self-explanatory. We talked about substantial gainful activity and severe impairment. Now, what is equal or meet a listing? So I wanted to talk a little bit more about that part. So what is a listing? Listings are a set of rules which cover the most common impairments and conditions, and which are grouped into categories. And they could be musculoskeletal, cardiac, and one of them is cancer. The listing sets forth a specific medical criteria needed to show per se disability. So basically, if a person meets that listing, they're found disabled per se. But in order to meet a listing, medical records must contain the specific test results and findings that are specified in a listing. If that isn't found, then one can equal a listing, which basically means that medical findings can show severity and duration that will equal the necessary test results and findings that would normally meet the listing. An applicant can also equal a listing if a condition is not found in the listing, but it is as severe as the nearest similar listing. So an example here is narcolepsy can equal the listing for epilepsy, and an argument can be made. So just to show you what a listing looks like, this one is for leukemia. So they basically will say that, it is a disability until at least 24 months from the date of diagnosis or relapse, or at least 12 months from the date of a bone marrow stem cell transplantation, whichever is later. So, or chronic leukemia as described in 1 or 2. So basically they go through this entire process to make sure that the person meets a listing. And as you can see here, for example, chronic, what does chronic mean to them? If from the date of the stem cell transplantation, there's any residual impairments or progressive disease following initial anti-cancer therapy. So as you can see, it's very specific. So when an argument is being made that somebody meets a listing, you have to be extremely specific and kind of really read into the listing and make sure it meets it. Just a quick note on children, the disability analysis is a little bit different. It is an evaluation of the child's ability to function at an appropriate age. So for infants and toddlers, it's basically growth and development and achieving major milestones. With school-age children, it is areas of academic performance, behavioral issues, and any physical limitations. The 1-year time limit is still relevant. And a note about preemies: if a child is born to 37 weeks and still hospitalized, parents can apply before the child's even discharged and receive benefits, because it's sort of a per se finding of disability. And this is the 3-step sequential evaluation process for children. Is the child working? Because sometimes they could be, because they're considered children until they're 18, so they could be working. Does the child have a severe impairment? Is the child's medical condition on the list? And they must have 2 marked limitations or 1 extreme limitation in these specific domains of functioning. So that's really the way that it is being evaluated for kids. So I wanted to give a bit of an overview of the process that Social Security goes through in order to receive benefits. So application is the first step. A person can apply online or by phone. But as many as 63% of initial applications are denied. Then a person can file a reconsideration. There are 60 days from the date of denial to request a reconsideration with the local Social Security office. It can also be done online. If the reconsideration is denied, then the applicant has 60 days from that date to file a request for hearing. And there will be a hearing before an administrative law judge, and that appeal can also be requested online. So the good news is as many as 70% of appeal cases are approved, especially where an applicant is represented. So that's sort of where we come in and make sure that they have everything that they need. If it is denied at the administrative law judge level, then there are 60 days to request a review with the appeals council, and that decision is the final decision of the agency. Any further appeals would require federal court. So we normally don't represent at the appeals council level. It's usually just up to the appeal level. So one thing I wanted to talk about that is extremely relevant to the population that we work with specifically is critical cases. And because Social Security, disability, and SSI can take a very long time to reach the initial decision, that's not even to say if it is denied and you have to file a reconsideration or file for an appeal. Sometimes it can take up to 2 years to reach a final decision if you have to go through a hearing and wait for that to be scheduled. I don't know if it's different in other states, but New York is extremely backlogged, so it takes us a really long time to get before a judge. But there are several circumstances in which Social Security will expedite an application, and these are critical cases. There's 3 categories that are relevant to cancer patients, and that's TERI, terminal diagnosis, CAL, which is compassionate allowance, and dire need. So just a note on the way that Social Security processes their applications. They use this predictive computer modeling program to analyze the electronic file for certain factors that show the high probability that the applicant will be found disabled. When this criteria is met, it is sent to a quick disability determination or QDD group. So it goes through a different route than someone who's filing based on something like back pain. So basically, you want to make sure that when you're submitting your electronic file, there are a lot of documents there that can be reviewed and can flag this for them. Then a QDD claim is reviewed by a disability examiner and can be approved solely based on the information in the application and medical record. A lot of times they don't request a medical consultant to look at the file. In a regular Social Security case, that would be the case. And a lot of times the person even has to go for an independent medical evaluation. They have to schedule that, they have to go before a doctor, and it takes a lot longer. The average QDD process is 15 to 20 days if the record is complete and the disability date can be quickly determined. Now, this is a bit tricky as well, because a lot of times when we speak to clients who are disabled and would like to state the date they were first diagnosed with cancer, for example, but they're continuing to work and they're gainfully employed at the moment, it may not be a good idea for them to argue that, because a lot of times it won't be found that that person is disabled if they're continuing to work. Substantial gainful employment issue here. So the date might have to be sort of moved around, and you just have to make sure that you're very clear about when that date is. It is very important to file for Social Security disability quickly if the diagnosis is severe. If the alleged onset date is more than a few months ago, QDD may deny the claim and put it through the normal determination process, because they sort of believe, like, if you waited such a long time, you could wait a little longer. So unfortunately, they will put it through the regular process. So it's better to do it as quickly as possible. Now back to the three compassionate allowance kind of categories that we wanted to talk about. So terminal illness or TERI, Social Security will expedite claims based on an allegation of terminal illness. Now, this condition is defined as untreatable, irreversible, and expected to end in death. Now, this is a tricky thing to talk about with clients because obviously we want to remain hopeful. And so I think it's important to note that the definition of expected to end in death is basically if the person does not receive treatment, it may be. So we want to sort of be clear about that, because sometimes our clients hear that and they're like, oh my gosh, this is horrible. I don't want this to be the case. So, but we do want them to get processed through TERI because it will be a lot faster. Social Security does expedite these at every step of the review, including, once it is approved. So these are the indicators of terminal illness. These are some cancer specific. So any malignant neoplasm, which is metastatic, defined as stage 4, persistent or recurrent following initial therapy, or inoperable or unresectable. Now, those are sort of the 4 things that need to be present in the medical record. Those exact words need to be present in order for them to find TERI. Also, there are some allegations of specific illnesses that would automatically make it TERI without having to go through those 4 stages, and that's AML, ALL, cancer of the esophagus, liver, pancreas, gallbladder, or brain, small or oat cell lung cancer, or mesothelioma. It's sort of a de facto finding of TERI there. Other conditions that I wanted to note that may not necessarily be cancer related, but basically anyone who's awaiting a transplant, not kidney or corneal though, a person who is comatose for 38 days or more, a newborn with a lethal or congenital defect, or chronic pulmonary or heart failure that requires continuous oxygen or a life-sustaining device will be sort of automatically TERI. And there's a list of them on the website as well. So you could check if the diagnosis of the person you're working with sort of fits into that. Now, compassionate allowances basically are conditions that by definition will qualify individuals as disabled by the Social Security standards. So it is in the best interest of the patient to expedite the application process. And again, many cancer diagnoses fall into this category. So for these, Social Security will require minimal objective medical evidence and will sometimes grant approval just knowing the diagnosis alone. So a lot of the times we have to submit hundreds of pages of medical record to prove that someone is disabled. In this kind of case, it is possible that it could be less documents, sometimes a medical letter from a doctor, just confirming a diagnosis, or a few pages of the medical record just showing the diagnosis is usually enough. So some cancer diagnoses that qualify as CAL is, again, acute leukemia, non-Hodgkin's lymphoma, central nervous system lymphoma, things like that. There's a long list of them, and it can be found on the Social Security website, but it's always good to sort of check and see if your client or the person you're working with qualifies for that. Now, in August of 2021, the Social Security's commissioner added 12 new compassionate allowance conditions. So those are the ones listed there. And now this includes 254 different conditions, and more than 700,000 applicants with severe disabilities have been approved through this accelerated CAL process. So it definitely is worth trying to go this route so that it could be done quicker. Now this one is a bit tricky. Dire need is technically another category, which is based on patients' financial needs. For example, if they don't have resources for food or medicine or shelter, Social Security can expedite the application process. It still requires the individual to satisfy the definition of disability. And now this is where it could become an issue, because even though they may try to expedite the case based on need, if the person doesn't have all the medical records they need, or basically can't show the date of disability, or something else is missing, it could still lengthen the process very much. And also, during COVID and during this period where a lot of people have been losing their jobs, pretty much every application is dire need. So I will be honest, it's probably harder to get this application, any application, to go through quicker just based on dire need alone. I would really lean on the TERI and CAL categories more than the dire need one, if possible. So how do you alert Social Security that a case is TERI, CAL, or dire need? Technically, they're supposed to be able to mark these cases on their own and recognize the signs. However, it is always much better if you can indicate that the patient or the client can be recognized as TERI, CAL, or dire need, because it will obviously help expedite the process. And it's never too late to denote this kind of case. So for example, if a person applied and they thought they had stage 3, but they went to another appointment and it was discovered that it progressed and it's now stage 4, you can submit that document. You can submit an advocacy letter, which will explain this kind of situation. So I've put up sort of a really quick sample advocacy letter that we've used. It doesn't have to be anything extremely lengthy, just sort of explaining the diagnosis, how this person meets a listing, and how this person qualifies for TERI or CAL processing, and just a request to expedite. We put in very big letters on top TERI case so that it catches attention, and we've had success with these kinds of letters. So I wanted to give more tips sort of about how we usually process applications and prepare for filing or appeals. So basically, we use something called charting. Medical records can be extremely long, thousands of pages sometimes, depending on how long a person was sick. And charting is a way to condense and organize it. Many of you may use the same thing, but I just thought it would be good to mention to basically include any impairments or symptoms that a person experiences, notes about when the condition started, what caused it, and how it impacts the person's life, and a summary and diagnosis at the end of any consultative exams, including mental status exams. So this is sort of what a chart, an example of charted records looks like. It quickly references page numbers and what diagnoses have happened, and if any issues could be seen, like a missed appointment, or progress notes, or he's bad at adhering to medications, for example. So that kind of charting really helps you as an advocate also to take a look at what you want to put in your advocacy letter. And it really helps Social Security, once this is submitted, to sort of figure out where everything is as well. Once records are charted, we go through those 5 steps that I showed in that big sort of green chart in the beginning. And once you're going through the 5-step process, one thing you ask yourself is, does the client meet a listing at step 3? That's the listings that we talked about. And if not, perhaps you can make an argument using step 4 and 5. Now, basically, those are the steps that include whether or not the person can do their past relevant work, and whether or not they can do any other job. And a lot of times that evaluation process also includes whether or not a person is, what age the person is and what their capacity for work is. And so I didn't get into too much detail here because there's a lot that can be talked about in Social Security, and we do have kind of a limited amount of time. But basically there are these things called grid rules, and a person could grid out, which basically means that if they are if they're a specific age, and if they have a specific job that they used to do, and whether or not that's light work or sedentary work, they may not be able to do that work anymore based on their age and disability. And sort of that makes them grid out of being able to work at all, even if they don't meet a listing. So,
Julie, it looks like there's sorry, I didn't mean to interrupt. Looks like there's a question in the chat as well. Do you need me to read it off, or?
No, I got it. Let me see. So are advocacy letters from an HCP on behalf of a patient for their application impactful, or is that something that only comes from MLP or legal advocate? No, I think it's still very much impactful. I don't think it has to come from a legal advocate necessarily. I think the best thing to do with advocacy letters is to kind of summarize, because a lot of times things can get lost in a very voluminous record. And so I think if a letter can summarize everything that is going on with the person's health and how their disability is affecting their daily life, and we'll see an example of that because I talk a little bit about advocacy letters that we usually write for clients. That could be extremely helpful because Social Security is notoriously bureaucratic, and a lot of times will like not wait for medical records to receive medical records in order to make their decision. Sometimes they'll request medical records from a facility and won't get them, and they'll have like 1 page or 2 pages from someone, maybe even the applicant themselves, and they'll make a decision based on that. And a lot of times that's a denial because there's just not enough to prove disability. So a letter can be extremely helpful. Of course, absolutely. So I wanted to mention a little bit about working with difficult clients, and I'm sure we all have a bit of experience in this, but I think that it's been extremely helpful to me as I was sort of learning to do this, and especially people who are applying for Social Security disability, who are very ill, who are dealing with so much stress. They can be short, they can be rude. So it is a thing that I think is really important. One thing that really helps is creating structure and letting them know that you have a limited amount of time for a meeting, or these are the 3 things we need to accomplish today. There's definitely boundary setting about your role. People will try to go to you for things that is not your job to do. And then you really need to manage your client's expectations. What our work together will look like. A lot of times it's about empowerment. It's about saying, I will be doing this, but you also have to do something here. Like you need to get your records, or you need to, have your doctor fill out this form. A lot of times some onus has to be placed on the client. And identify other players. A lot of times they do really need a support system. and who can help them obtain a document, right? A lot of times they can't be the person that goes to the doctor to ask for a letter because they are too sick or they don't feel comfortable. Can a social worker help? Can a family member help? It's been imperative for us, and we often work with social workers and family members in order to get things accomplished. The next step in the process is an interview that will happen with Social Security. And this is important information that a client should have on hand. And, you know, it's employment information, education, earnings and income, banking, especially if the client wants the benefit to be directly deposited, and of course, medical information. They need to have a list of their physical and mental conditions. I find that it really helps to write this down because a lot of times clients forget. A lot of times clients want to be brave, and they'll talk about how they're feeling on a good day, but not on their worst day. And one thing I really recommend is that when they speak to Social Security, they really describe their worst day and all the symptoms that they're experiencing then. Dates and types of treatment, medication list, that's extremely important because a lot of these medications are very complicated names, so it's good to have a list and how often you're taking them and for what condition. It's really helpful to have. So once the application is submitted, the Social Security representatives in the local office will verify all the non-medical eligibility requirements. So that's what we talked about, like immigration status, whether a person has worked enough, if it's a Social Security disability application, for example, whether they have enough work credits and they worked late enough, like recently enough in order to qualify, and other things like that. Then Social Security contracts with the state disability determination services, and they are responsible for developing the medical evidence and deciding, that's the initial determination, whether or not the applicant is disabled under the law. So there's a claims analyst, which will collect and review evidence, and that's all the medical records, all the evaluations. And this person may order a consultative exam. So a consultative exam doesn't happen in every single case, certainly doesn't happen in cases that are Terry or Cal, where it's very obvious that a person is extremely sick, but they can happen where the illness isn't very obvious, or if there's some doubt, I guess, by Social Security that the person is as sick as they say they are. The consultative examinations happen with a doctor that's not the primary physician of the applicant. It is a Social Security contracted doctor, and they do those examinations, both physical and mental. And the claims analyst would be contacting the treating sources. So physicians, if there's social workers, if there's mental health providers, they would be contacting them for any information that is missing. Technically, that's what they're supposed to do. But I will say practically, a lot of times they do not. And it is the onus sort of falls on the client or their representative to make sure that all that evidence is provided. Once the initial disability determination is made, the DDS will return the case to the local office for appropriate action. So either after approval, benefits will begin, or the office will issue a denial notice and explain the appeal rights of the person. So basically just some advocacy tips for Social Security disability. We want to establish the earliest possible onset date, which is the date that the client became disabled and unable to work. This, of course, has to be supported by medical evidence and work history. So that's what I kind of talked about, is sometimes a person will be diagnosed with cancer, but they continue to work for another 5 months. And then, they then get sick enough that they have to stop working. A lot of times we can't claim that initial date, we have to claim a later date, like the date they stopped working, because it doesn't get approved if the person continued to be gainfully employed for those 5 months. Why the onset date is important is because there is a 5-month statutory waiting period from the onset date until the benefits can be paid. And during those 5 months, no payments are made. So unfortunately, obviously, you want to kind of get this as early as possible. That way that 5-month waiting period can be shorter. Hopefully it already sort of has passed. So retroactive benefits for Social Security disability can be paid up to 12 months prior to the date of application. So if a person applies kind of late to Social Security and says, actually, I've been sick from a year ago, they can get those benefits paid out. Also, retroactive benefits will happen if a person applied, was denied, appealed, waited 2 years to get a hearing, finally won the hearing, they will get a lump sum payment from the date that they were considered disabled, which in my experience sometimes could be like 5 years ago, and they could have a huge lump sum payment. So that's kind of great for them. Okay. So writing an advocacy letter, this goes towards the question that we had earlier. So it could be very helpful to the client's case. So this is sort of geared more towards the legal representation side, but honestly, it could be anyone who sort of talks about this kind of thing. Basically, we're arguing why the client cannot work. We have to make sure to include if they need a listing or kind of following those 5 sequential steps. It's sort of more of like a legal way of doing that. But we include details on education, previous work, why they can't perform this job, all their medical conditions, how they affect the client. And we talk about adherence to treatment, because that's one thing that's really important. A lot of times if, for example, you are being treated for an illness that requires that you show up to appointments and take medication, but you don't show up to appointments or don't take medication, Social Security will make the argument that if you did, you wouldn't be disabled and you'd be able to work and you'd be fine. So it's really difficult to win that kind of case and be granted disability. You do have to have adherence to treatment. However, if there is poor adherence to treatment, you might be able to argue their lack of cooperation is due to their condition. So if they have depression, anxiety, and such things like that, that could be an argument made. So I'm going to show a sample letter. It's very lengthy, so I just kind of highlighted the really important parts. We kind of say who we are, who we're representing, how many pages of medical records we're including, from what hospital. Then we're talking about where the person was employed, what conditions they're suffering from. And as you see, we say that claimant's diagnosis should be found to meet or equal a listing. And we kind of explain why we think that and why it satisfies, which parts of the listing. Yes, and so basically we just make the argument that this person is disabled and to find them disabled. This is another sample where we talk about grid rules, which is something that I very briefly mentioned again because we have limited time, but we talk about not only is this person unable to perform any past skill work, but this person is of advanced age and cannot basically transferred over to any other job in the national economy, would not be able to do anything else, and would otherwise be found disabled under this grid rule. So those are kind of 2 examples of advocacy letters. After submission, you can follow up with the analyst in about a month after you mailed all the evidence if no decision has been made, but it can take anywhere between 1 to 6 months for a decision. Sometimes longer due to COVID closures. We have seen it take a very long time sometimes. Fortunately, with Terry and Cal, it's still being processed much faster, but for regular cases, it can take 1 to 6 months. If approved, celebrate. If denied, you can ask for reconsideration online. And if that's denied, the next step is to request a hearing before an ALJ. A couple miscellaneous notes. Drug and alcohol issues. Sometimes this comes up as a problem because this alone cannot be the basis of disability determination. But for the substance abuse, would the claimant still be disabled? So it does not apply to conditions that are disabling on their own, even if they result from substance abuse. So for example, end-stage liver disease or irreversible organic brain disorders. So even if the impairment would not improve if the substance abuse stopped, then this is an exception to this rule. Okay, some final takeaways and tips. Following up with SSA is extremely important. They're notoriously bad at saying things like, yes, we received your fax and put it on someone's desk and no one has looked at it and we don't know where it is. So it's very important to make sure that you're following up and make sure that they've received the documents that you need. Keep receipts and records of conversations with people, email or fax where you can so you have proof that you actually submitted something, and follow up to make sure that things are received. Even if you mark the case as one of 3 critical types, you should confirm with Social Security that it's being considered as such and is being processed quicker. If there is a hearing, make sure that there is access to the electronic record system and verify that those records have been exhibited properly and fully. This is more for legal representatives who would represent someone at a hearing. And expect Social Security to deny the case at every stage. Like I said, so many of them, of the initial applications, are denied, but upon appeal, so many are approved. So there's still good news. So those are sort of my tips. And sorry if I went a little fast. I just wanted to make sure that we had a bit of time for questions. So please unmute yourself, and I'm happy to answer whatever questions you have. And this is for more information on NCLSN or to become a member. This is Allison's contact information. Please consider that while I wait for questions, if there are any. No, don't be shy. Okay, if there are no questions, I guess we will end this training for today. I hope that was helpful, and I look forward to seeing the rest of you, all of you, in another training that we should have coming up very soon and in our further meetings. Please reach out if you have any questions to Allison, and she can forward that information to me. Thank you. Take care, everybody.